Hi, my name is Shamir and my UH ID is 24105503. This presentation analyzes the legal right and remedies available to Bob Decor. Following two defective deliveries by would create under contract for sales of goods, we will apply the Sale of Good Act 1979. SGA 1979, the Consumer Right Act 2015 is not applicable as both parties are businesses and relevant case law. The key issues are number one, whether goods conform with contract, number two, whether both can reject good under an installment contract, and then number three, the right to repudiate. This is an important area of commercial law with significant parties implement for business to business transactions. In slide 2, on the 10th May, Bob placed an order with WC Limited. The contract is disabled installment contract for the sales of goods governed by the Sale of Goods Act 1979. Each installment should have consisted of 4 oak dining table measuring 1.5 meter each and 20 wooden chairs. Packaged in two boxes of 10 on the 20 May, WC Ltd delivered 5 AS table measuring 2 meters. Wrong species, wrong measurement and wrong quantity. Only 15 chairs were delivered in one box rather than two boxes of 10. On 23 May, two oak tables were delivered correct species but wrong quantity and 15 chairs this time is in the into two boxes. We must assess each delivery against the implicant terms in the SGA 1979. In slide 3, section 13 of the SGA 1979 implies the condition that where goods are sold by description, they must corresponding with description in Arcos Ltd. Vir Renaissance Sons 1933. AC 47, the House of Lords held the court must precisely conform to their contractual description even if the buyer suffers no practical prejudice. The table's order were described as of 1.5 meters. The delivery of a table measuring 2 meters is a clear breach of S13. Similarly, the chairs were to be delivered in boxes of 10, delivering 15 chairs in one box breach the delivery description. Section 14 by 2 implies a condition that goods are satisfactory quality, although the S table must be good quality in themselves. They do not match what was contracted for. Section 14 by 3 adds fitness for the purpose the buyer intended purpose was oak table of specified dimension. The wrong species or wrong sized undermine the purpose. In slide 4, section 30 of SGA 1979 deal with delivery of wrong quantity. Section 30 by 1 provided that what the seller delivers a quantity less than contracted for the buyer may reject them or accept and pay at the contract rate. Section 32 provides that where the seller delivers a quantity larger than a contracted for the buyer may accept the contract quantity and reject the rest or reject the whole. Looking at the first installment, Bo was entitled to 4 tables and 20 chairs. He received 5 tables, excuses and only 15 cheer shorts. So S30 by 1 and S30 by 2 are both engaged for the second installment. Only two oaks tables were delivered short of 4 and 15 chairs. Short of 20, this is a clear short delivery under S30 by 1. Importantly, note that S32 by A inserted by the Sales and Supplies of Good Act 1994, provided that a buyer who does not deal as consumer can't reject if the shortfall is so slight it would be unreasonable to reject. However, airport deliveries involve significant dispenses both quantity and quality. In slide 5, there is the key provision of both situations. Section 31 by 2 of SGA 1979 governs the installment contract. Central question is whether the breach of first two installment amount to be repercussion of the contract in the Maple Flow Coal Ltd versus Universal Furniture Product Limited 1934 1 KB 148, the Court of Appeal set off the definition two-part test. First, the ratio how large a proportion of contract in is the breach, both in the relation to the whole contract and to the future delivery. Second, the probability how likely is that breach will be repeated? Applying the above situation, 2 of 3 installment has been defective. This is a ratio of 66%. The breach have occurred in the board delivery suggestion a pattern of non-compliance. In slide 6, applying the Maple Flocks test to the above situation on the ratio limbs. The breach were not trivial or isolated. The first delivery delivered the wrong wood species, entirely the wrong dimension, wrong quantity of the table, and a incorrect packaging of the chair. Every single contractor requirement was breached. The second delivery also delivered wrong quantity. Together, 2 out of 3 installments, 66% of the contract has been defectively performed on the probability of limb. WC Limited has failed to deliver correctly on both occasions. There is no indication they will rectify performance. The constituent pattern strongly suggests the third delivery will also be defective. In the Withers versus Reynolds 1839 2B and AD 2, the court had the precedent non-payment entirely that seller not to treat contract as repudiated by analog note performance entity the buyer to the same conclusion. Therefore, Bob is likely intended to treat contract as repudiated and cancel the third delivery due to 26 May. In slide 7, before Bob reject was we must consider what has lost data right through exception. Section 15A SGA 1979 inserted by the Sale and Supply of Good Act. 1994 restricts the right of reject for non-consumer buyer if the breach is so slight it would be unreasonable to reject. Here the breach or substance, wrong species of the wood, wrong dimension, wrong quantity. Section 15A does not apply to deprive both of his rights. Section 35 SGA 1979 set out the rule on the acceptance a buyer is deemed to have accepted goods if intimate exception do not in consonant with the seller ownership or. Today 23, the second delivery has arrived as not used their goods integrate and intention to keep them. The old case is Burstyn versus Benson Motor 2 all ER 22 previously caused difficulties by treating a relatively short period as exception, but this was reformed by 1994. The aimed section 35 by 5 now provide that the buyer is allowed a reasonable opportunity to examine goods, and a buyer who has not been given such opportunity is deemed to have accepted them. In slide 8, let us now consider both practically remedies. First rejection, the first installment has not been accepted. Goods 20 May can be rejected. Rejection terminates subcontract for the installment of recovery and price paid. Second rejection of the installment, the two tables, 15 chairs and 23 May are not confirming in the quantity of rejected these two. He has two reasonable opportunity to inspect. To the delivery date, third cancel of third delivery under S31 to applying the Maple Flock ratio probability test. Bob can repute the whole contract. He need not to accept third delivery on 26 May for damage under S51 SGA 97 where the seller is wrongfully refused to deliver. The buyer may recover the difference between the contract price and available market. Bob. Bob should lose the example has lost a customer order due to non-delivery goods. In slide 3, academically commentary strong supported Bob position professionally. Michael Bridges' seminal text where there are multiple breaches across multiple installment code have consistently held that the buyer intended to reproduce Ataya Adams and McQueen note the strictness S13 in the commercial contract in deliberates. Parties contracting for the specific goods by description do so for the reason that cannot be accepted to accept for fundamentally different goods. The Law Commission Report 160 of 1987, which leads to the Sale and Supply Good Act 1994, is important context. The Commission recommended narrowing the right to reject over the travel defection, making clear the substandard non-comforted must continue attract full remedy e-rejection. Bob is not to required accept defective goods and seek price reduction. His right to receive exactly what he contracted for is protected by the Act. In slide 10, in the conclusion, Bob has strong grounded to reject all the goods received and cancel the third delivery. The first installment breached the implicit terms so as to description under S13, satisfactory quality under S14 2, and quality under section 31 and 32 of the Sale Goods Act 1979, the second installment breach, so S31 with the short delivery of both tables and chairs. Bob has not to accepted the goods under S35 and S15. A does not deprive him all the right reject because the breach are substantial. Applying the Maple Frog test under S31 by 2, the ratio of defective installment 2 out of 3 is high and the probability of recurrence is significant given WC Ltd constitution pattern. Bob should send a written notice of rejection to WC Ltd promptly, make the good available for the collection and claim full refund and payment made. He or may also preserve damage for any consequence losses under S51 and the principle in the Hadley versus Baxter. Thank you. I am happy to take any question.